This is Democracy Watch. I'm joined by my co-host, voting rights attorney, and the founder of Democracy Docket, Marc Elias. So, Marc, your firm has filed a challenge to Wisconsin's absentee voting rules in a case that will have major implications in the tipping point state, that's Wisconsin. Can you explain what your lawsuit is seeking to do?
Sure. So we filed this lawsuit to try to do four things. Okay. Number one, there was a prior ruling that banned Dropboxes across the board in Wisconsin. We think that that is wrong and violates Wisconsin law and the Wisconsin Constitution. So, number one, this is an effort to allow jurisdictions to have Dropboxes. You would not think that this would be controversial, but nevertheless, here we are. Number two, Wisconsin has a very strict witness requirement for witnessing absentee ballots. And we think that that witness requirement transgresses state law as well. I'm sorry, state constitution as well, I should say. And so we're challenging that. Number three, Wisconsin has a very tight cure deadline. So this is where someone fills out their absentee ballot and maybe they miss including something, they leave out a date or a complete address or something. And so Wisconsin requires that ballots be cured by 8 p.m. on election day, which really makes it an outlier in the country. I mean, it makes it an outlier in even in some pretty states with some pretty repressive voting laws. There's no practical way that for a lot of voters that they're going to even know they made a mistake
Right.
by 8 p.m. on election day. I mean, people don't make mistakes and then immediately are like, oh, look, I made a mistake. So usually the cure periods take place after election day because at that point, people have lists of what ballots were rejected and people are given an opportunity to be notified and cure them within a little bit afterwards. And the final thing, which I think is a really big one, but may be overlooked a little bit in the lawsuit. You know, Wisconsin, the Wisconsin courts have interpreted absentee voting as a privilege, not a right. And I just think that's really antiquated. You know, I came across this principle years and years ago, you know, not in Wisconsin, this dichotomy between a right to vote in person and a privilege to vote by mail. And I just think that that does not hold up in modern society. And I think that it's time for Wisconsin courts to recognize that voting is a right. The means of voting, how you effectuate the right is really should not undermine or qualify that right. So I think it's really important that the Wisconsin courts here affirm that voting in all of its methods is a fundamental right.
Okay, now the first point you mentioned was about Dropboxes. The Wisconsin Supreme Court back in 2022 banned Dropboxes. Given that there's a new liberal majority on the court with the election of Judge Janet Protasiewicz, can the court consider the same exact case and possibly make a new ruling on the legality of Dropboxes in Wisconsin?
Look, so this case has been brought in the trial court in Dane County. Obviously, it acknowledges the existing law. You know, oftentimes when you bring litigation, there is existing law that is contrary to what you believe the proper interpretation of the law is. So right now, that case is in the trial court. We are looking forward to putting forward an evidentiary case there. I know the lawyers working on the case at my firm are hard at work on that. And then, you know, eventually it will presumably work its way up the court system in Wisconsin, like lots of cases do. But for now, the real focal point of this case is in the trial court.
Okay. Now, in terms of a lot of the restrictions that you're pushing back against or that you're fighting in the courts, what kind of an impact have these burdensome rules had on Wisconsin voters?
You know, every ballot tells a story. And for most of us, the story it tells is about civic engagement and civic pride. But for all too many people in Wisconsin and around the country, the story it tells is about the heartbreak of losing one's right to vote, losing one's vote, losing one's voice in an election because some technicality made it either impossible for the voter to vote or have their vote not counted. So when you look at the impact of a lack of drop boxes, you know, what you need to understand is that the impact is on real voters. It means that some number of voters who otherwise want to vote, want to have their voice heard in an election, will remain silent because a state court is banning metal containers, secure metal containers where you don't need a stamp, in favor of secure metal containers where you do need a stamp.
Yeah.
And that kind of arbitrary thing is just like, it's a tragedy for democracy. The same is true with the cure provisions. No voter should lose their right to vote because they made an innocent error on the way in which they filled out the outer envelope that they were putting in the mail.
A process that's already not the simplest process to begin with for someone who's not familiar with this stuff.
Sure, even people familiar with it, you can make a mistake.
Right.
You shouldn't lose your right to vote because you made a mistake or because the election official trying to interpret a bunch of complicated election laws, they made a mistake. And we see that also. So these have real impacts on voters. And that's really what the centerpiece of these cases is about. And it's really what we all ought to center around when we talk about voting rights.
When Republicans bring this stuff to court to defend their actions, is there any need for them to actually prove that any of the moves that they've made were warranted? Like to show that Dropboxes were dangerous, to show that they need to have a stamp versus not have a stamp, to show that it needs to be cured by 8 p.m. on election day versus 2 or 3 days after? Like, don't they have to prove that any of this stuff is actually necessary?
So you ask a really, really important question. I hope everyone listens to this question and this answer, because it's one of the problems with voting jurisprudence, a terrible word that people hate, but it is true. It is one of the problems with voting jurisprudence. Why is it important to say that the right to vote is a right? Because when a state deprives someone of a right, like you said, they have to show there was a really good reason. Right? They can't just deprive you of a right because it's convenient for them. They have to show you there's a really good reason. But if something's a privilege, well, then, the state can take away privileges because they just decide they don't want to provide privilege anymore. The state could, the county could say, it was a privilege for us to operate a golf course. We've decided we're closing the golf course because we don't have enough money for a golf course. But that's different than a right. And so when we talk about this issue of is there a right to vote absentee in Wisconsin, it has a meaningful impact on what the burden of proof is. Beyond that, the first thing that Republicans have to do in defending these laws is to say that the law actually says what they say it says. It's not at all clear that there is a law that prohibits Dropboxes in Wisconsin. I mean, I defy a Republican lawyer to point to the place where it says you can't have Dropboxes, right? They are interpreting the law to say that it doesn't allow Dropboxes. And then you get to the question of whether or not, if it does say it in the law, then what is the constitutional proof? What is the proof that each side has to put on? So there's multi-levels to this. The lawyers involved in this I think, going to really air some really important issues. And I really hope the courts hear this evidence and consider this case carefully.
Do you assume that this case will also go to the Wisconsin Supreme Court?
So look, I assume that every case that gets filed that involve elections will get appealed.
Yeah.
So do I think it goes to the Wisconsin Supreme Court? Sure, probably. It doesn't necessarily have to. I mean, it's possible that the trial court, rules at least on some issues. It feels like it's able to grant the relief we want. And the Republicans, it's really surreal because there's kind of a split screen. I'm sure you saw this article. There was just an article about how Republicans are promoting vote by mail and early voting. They're actually I think the RNC set up like a hotline to tell their people to vote by mail. So there's always a possibility that the Republicans are like, why are we fighting this thing that we are also simultaneously saying we want our people to do? I think that it's unlikely. And I think that it's more likely this case winds up weaving its way through the Wisconsin courts.
Yeah. Will there be enough time to litigate this all before the 2024 election, assuming that the defendants will, almost invariably appeal this to the Wisconsin Supreme Court?
Yeah, look, I think there's plenty of time to have this case heard. I think, I have a clock, having done this for 20 some odd years. I have an internal clock of when I start to feel like, okay, we're getting too late. We're getting too late. We're getting too late. It's not too late to be challenging restrictive voting laws yet. We're still solidly over a year away from the election. There's been no movement on ballot qualification or primary elections that you start to get more complicated. So I'm confident this case will get resolved in time for 2024.
With that said, are there any cases across the country where you do have a little bit of hesitation, nervousness about it being resolved in time? A case that might have bigger implications like this one in Wisconsin?
Yeah, look, I worry there are some cases frankly, that were filed before last election that didn't get resolved. You look at some of the litigation involving Georgia SB 202, or Texas SB1. You know, there was a time when the country was really focused on those cases. SB1 was the Texas law that the Democrats walked out of the legislature over. SB 202 was the law that led to the moving of the All-Star game by Major League Baseball. Those cases are still grinding away. Now, do I think they'll get resolved for 2024? Yes, but it's these big omnibus laws with lots and lots of parties making, with lots and lots of arguments, that sometimes the state can just wear you down, and they don't get resolved in time for elections. So, but it's really the obligation. You know, if there's something I could say to every lawyer involved in a voting case right now, whether they're at my firm or another firm, it's our obligation to push these cases on the docket, make sure we are moving them so that voters have the voting rights they're going to have, and they're going to have them in time for 2024.
Well, that seems like the perfect place to end. So, Marc, as always, thank you to you and your team for the work that you're doing to protect voting rights across the country. In particular, this very case in Wisconsin, which, as we know, is among the most important states every single election. So, for anybody watching, if you want to help Marc and support him and his team, then please sign up for Democracy Docket. It's a free news outlet focused on voting and elections. The link is right here on the screen. It's also in the post description of this video. I'm Brian Teller Cohen.
I'm Marc Elias.
This is Democracy Watch.